now in session. All who have cause to plead, draw near, give attention, and you shall be heard. God save the United States, great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Welcome to the Florida Supreme Court. First case of the day is the advisory opinion to the Attorney General. You may proceed.
Good morning, Mr. Chief Justice, and may it please the Court. I'm Alan Windsor on behalf of the Attorney General, and we are here today on the Attorney General's request for an opinion. Mr. Mills is here on behalf of the sponsor, and he'll be arguing in favor of ballot placement. And then with the Court's permission, I will return and present the arguments of those who have filed briefs opposing ballot placement, including the Attorney General, the Florida House of Representatives, and the Florida Senate. And Mr. Nordby is here on behalf of the legislature. And Mr. Bell is here on behalf of the 5 other parties who have filed a brief: the Florida Chamber of Commerce, the Florida Medical Association, the Florida Police Chiefs Association, the Florida Sheriff's Association, and Save Our Society from Drugs.
Thank you.
May it please the Court. My name is John Mills, counsel for the proponent. With me at counsel table is Tim McClendon. Today, this Court is asked to address 2 specific issues. That is, does the proposed amendment meet the single subject rule? And does the proposed amendment and its title and summary accurately portray what its actual effects are to the voters of Florida? If I may, I'll address the issue of title and summary first.
Would you go directly to, really what seems to be a real heart of this, the title and summary, talking about the debilitating kinds of conditions, yet the actual bill, or the language contains such a broad catch-all that anything basically that a doctor prescribes it for is what it seems to be, without the hook or the nexus to the debilitating aspect of a disease or condition.
Yes, sir. The issue of the actual determination of who may receive treatment is determined in both the definition and the definition of how to certify a particular patient. So, putting that in context, if I were a patient, or if a patient were in pain, were receiving treatment, they would go to a doctor and say, my condition, doctor, I have throat pain, I can't sleep, I'm having a problem eating. What are my options? Doctor said, well, perhaps we can do oxycodone. That's an option. And if this amendment were in effect, say you could consider medical marijuana. Now, let's look at first, in certification, I must look at your condition, which is the issue you're discussing. So if I have one of the listed conditions, then I partially qualify, because the doctor must assess in his professional judgment that the benefit outweighs the risk. Say, for example, if I were in cancer treatment, but I wasn't in pain and there was nothing that those particular drugs could do for me, the benefits would not necessarily outweigh the risks. So that list is a starting point, and those are diseases. There is an additional clause, and that clause is or conditions as determined. Now, the sponsors were focused on 2 things: the patient and how best to make that determination for a patient, which is very much focused on physician decision. So a list alone would not be adequate. So the issue is, how does this clause fit? The clause fits. It is in the definition of debilitating medical conditions. You can't read a clause without reading it in context. As a matter of fact, if you go to Constitutional Interpretation 101, it's text and context. So you have to read that clause in the context of the provision. It is the debilitating medical condition term is used in several places, most particularly, and I think importantly, in Section 9, which is if I'm a certifying physician, I must determine you have a debilitating medical condition and that the medical benefits outweigh the risks.
You seem to want to include the words "or other similar conditions," but that's not there.
Well, because of the context, Your Honor, those words would actually not be necessary.
Well, it seems like the way I read it, it would seem to be, you know, if a student's just stressed over exams and they go in and see a doctor and they said, you know, I'm really stressed out. Well, I've got something I can help you with, and prescribes marijuana. Wouldn't that be included in this?
No, Your Honor, and they're not in my opinion. And of course, the issue is not my opinion. The issue is the opinion of a doctor who has professional responsibilities to assess a condition. And you must read into this condition. I understand what you're suggesting, and I understand the opponent's argument, that this condition and the terms condition relates to the rest of the statute. I mean, you've done that many times. When there are different clauses that relate, you read them both.
We seem to be in an interesting dilemma here, perhaps, which is that the proponents are saying the intent of this constitutional amendment is not to have a open-ended use of marijuana for medical purposes, for anything. And you state that as, I guess, as the drafter or whoever drafted it, that the intent was not that, and that you've got to read subsection 1 in conjunction with subsection 9. So I was looking to see if there are any cases which really the summary is potentially misleading. If this is meant to be an open-ended, the doctor can just prescribe it like, you know, you take something for a headache or Valium or for stress. Or is it more narrow? How do we, so we're into a constitutional amendment that may itself not be entirely clear as to the intent. So do we have any cases where the intent is to be, you're saying the intent was to be more narrow than the opponents of this, but we're reading it, and if you just read subsection 1, it doesn't say or other similar conditions. It seems to just be freestanding as to the benefits have to outweigh the risks. So do you understand? So we first have to decide what the intent of the constitutional amendment is before we can decide whether the summary is misleading.
Yes, I understand.
And do we have any cases?
Your job is to compare.
Do we have any cases, though, that's first, where the court first says, well, we're going to accept, I kept on thinking we had one, I just couldn't find it. We're going to have to accept what the proponent says the scope is, which is a narrow scope, not a broad scope, and then it wouldn't be misleading because there's a reasonable interpretation, which you're advancing, that the proponents did not mean for this to be broad.
Well, the court certainly has the right to interpret the provision.
Well, don't we have to, I guess the question is, don't we have to in this situation?
Yes, you have to interpret the provision.
So how do we do that? So you're saying that if we were here, say there was a doctor that was being prosecuted because he had or she had prescribed marijuana for somebody who had anxiety over an exam, and they were being prosecuted for that. Somebody would be here arguing, well, no, that doctor could prescribe it for that because the benefits, I don't think there are any risks in marijuana, so I think I can prescribe it for just about anything. And we have to be interpreting the constitutional provision.
Well, you would. If you're in that position, what you would do is you would employ all of those statutory canons of construction, and you'd look at intent and the intent of the sponsors.
So you
And
think
the
this
intent of the-
B9 is you think B9 has to be, because if you read just subsection 1, you really come up with the interpretation the Attorney General has put on it. But if you look at 9, it appears to really narrow the scope of what can be done.
I think you have to read, yes, you have to read B9, and you have to read even that subsection. And there's the old legislative interpretation of justum generis, and the generically, the topics that are addressed in that definition section are serious diseases. And it is counterintuitive.
But isn't that list separated by an or?
It is.
From the last part, which says other conditions for which a physician believes, and it believes that the medical use of marijuana would likely outweigh the potential health risks for a patient. It seems like to me if the intent was to only include conditions that were similar because they were also debilitating, that's not the way the language would be. As Justice Polston suggested, it seems that there would have been some reference to other similar conditions. But that's not what it says. So I don't see how that canon really comes into play in this particular context, given the structure of this. Why am I wrong?
Even in plain meaning, which is the most removed and most isolated of interpretations, you have to view context. And the context isn't necessarily just the next word. This case, this court in locally approved gaming, which was another initiative, dealt with interpretation of a clause that, in fact, the Attorney General argued was misleading because all counties over 500,000 must have casinos. But there was another clause that said they had to vote, and this court said you had to read those together to understand what was going on. And the precedence of this court, and we're talking about the issue of fairly informing voters, again, you have to look at the title and summary and the actual text and interpretation. And the title and summary here includes certain medical conditions and debilitating diseases.
Well, it says debilitating diseases as determined by a licensed physician.
As determined by a licensed physician, which frankly is the core of this.
I looked up the dictionary definition of debilitating. There's both the medical definition as well as the Webster, and it doesn't, at first I thought, well, debilitating must mean, like, again, you've got ALS and you're just not going, and apparently, and that's, so the idea that debilitating, I guess, it's not serious debilitating illnesses. It's
debilitating, and by the way, another state that has used a similar definition to that we have is Massachusetts, and they're implementing regulations, et cetera, consistent with our interpretation, and they define debilitating.
Well, in subsection 9, when it references debilitating medical condition and for the doctor to certify, would you not go back to the definition provided within his constitutional amendment?
Well, you would, and therefore, reading the two in context, that's really one of our major points.
We still get back to what it means in the definitional clause of B1, right?
Well, if you read this in context and in conjunction with B9, and if, as the opponent suggests, you could determine that a debilitating condition was only for that which the benefit outweighed the risk, then subsection 9, a certifying doctor would certify that the benefits outweigh the risk and the benefits outweigh the risk. And that doesn't make sense. In other words, subsection 9 says you have to certify a debilitating medical condition and that the benefits outweigh the risk. And that's what you want.
But the way it's drafted in the first section, it seems, as you say, if you had cancer the doctor could prescribe medical marijuana, even though they didn't determine that benefits outweigh the risk. But you can't, I mean, the way this is, I don't want to, shoot the messenger here, so to speak, but this definition doesn't, when it says, or other conditions where the benefits outweigh the risk, doesn't appear to, if you just look at that, relate back to those conditions such as glaucoma, the various. Do you see do you understand what I'm saying as to just that?
Yes, and I'm trying to suggest that you actually need to look at subsection 9, which is where these decisions are going to be made. That certification which is written, the physician will have to say what that debilitating condition is and report that to the Department of Health. And that the benefit outweigh the risk, and that's two separate decisions. And they both have to exist.
Let me ask you a quick, right now we do have, doctors can prescribe a lot of medications that are controlled substances under our criminal laws. And I'm just wondering how this one fits in with all of these other substances that doctors can prescribe. And are they bound by the same kind of language that we have in this proposed constitutional amendment?
Doctors that are prescribing controlled substances or their Section 2 or controlled substances, there's a particular statute, 456, that actually tells them how to conduct a physical examination. If you're prescribing controlled substances, you actually have to use a different kind of paper, and you have to report it. So one of the major issues in trying to reduce the abuse of oxycodone was reporting to the Department of Health. That's one of the provisions that's included here, is that the doctor in the certification process reports to the Department of Health. One thing that's included here that isn't included is the actual patient identification. The patient has to obtain identification from the Department of Health. So they're distinct tracks. And the doctor still has the same obligation.
So every patient under this that is prescribed medical marijuana will be known to the Department of Health, and for each patient, the doctor has to fill out one of these certificates.
That's correct.
So and again, this goes back to, I guess, my earlier question. I don't know if you did have an answer. Has there been a case involving a ballot title and summary where the first aspect of our deciding whether the title and summary were misleading was to construe the constitutional amendment, and two different interpretations were given, where if it's a broad, you can just prescribe it for a headache, it's potentially misleading, but if it's more narrow, it's not misleading. Have we said, well, if the proponents are saying this is the way it's intended and that's a reasonable interpretation, then the ballot summary is not misleading? We have any cases like that?
Well, yes. Give you a couple of examples. There are a whole series of cases that this court has removed, going back to the Askew case dealing with lobbying, the Armstrong case dealing with death penalty. These were, the issue of whether it's misleading is whether the title and summary actually seriously misstate and mislead an average voter so they would not be able to make an intelligent vote. In those cases, they're directly misled. There's the SLU case, which dealt with the Tax and Budget Reform Commission, where the actual language and the effect of the language was that there would be a tax break for a year, but that wouldn't be permanent, and the title and summary suggested there was. There's the treatment and rehabilitation case, which this court approved, is a pretty good example of an argument about what the text meant. And in that case, it dealt with...
you're talking about the right to treatment and rehabilitation for nonviolent drug offenses?
Yes.
Yeah, I looked at that, and I think that is a pretty interesting statement of the law and our our standards, but I didn't think that the text, that somebody was arguing that the constitutional amendment itself was different.
Well,
than
I
what
think
the
they
proponents
were.
Okay, well,
I think they were saying that the constitutional amendment limited those who qualified for treatment and rehabilitation to single offenses, but those offenses could be on 2 different dates, but they could be multiple offenses on a single date. So those that are opposing it say that's misleading to say it's 2 offenses. And there is an analogy here because you have conditions that are summarizing. And you have 75 words, and this court has referred to that issue in other cases. So what you must look at is what the title and summary explains and what this does. And
Well, let me ask you this. If we concluded that under the language of subsection B1, the definition of debilitating medical condition, a physician would be authorized to give a certification
to do anything?
pursuant to this provision, in any circumstance where the physician believes that the medical use of marijuana would likely outweigh the potential health risk for a patient. If we believe that that's what the physician would be allowed to do, would you agree, based on that interpretation? I understand you're suggesting that's not the correct interpretation, but if that's the interpretation that we decide makes the most sense when we look at the whole context of everything here, would you agree that the ballot summary that makes references to individuals with debilitating diseases as determined by a licensed Florida physician would be misleading?
Well, that certainly improves the argument. It seems...
Well, I think that's good. I mean, I think the way I understand it, I think this whole question all turns on that. And it seems like to me, if we conclude that that is the correct interpretation, the interpretation I explained, which gives force to that last phrase after the or in subsection B1, then that seems to be very different than what the ballot summary suggests by referring to debilitating diseases, because the voter thinking about debilitating diseases is going to have a very different idea than what would be authorized here, where a physician is simply looking at the risk and benefit. In every case, it's a risk and benefit analysis. And obviously, that's going to depend on the physician's outlook on these issues.
But I would suggest one thing, and I'd like to conclude so I can preserve my time, but that the court has always read the title and summary together, and I totally understand your point. The title in this case is certain medical conditions, which is a broad statement, not as broad as suggested by the opponents. But if the issue is, does the average voter understand that medical marijuana is being authorized by physicians, and that is, among other things, the limitations on the distribution, it's a pretty broad statement. But I understand your position.
But that has to be, doesn't that have to be understood in the context of what the ballot summary says, what the voter's looking at? It's not just is the ballot title, which is followed by the ballot summary, which makes that reference to debilitating diseases as determined by a licensed Florida physician.
And Your Honor, you must read those two together.
Which means you have to look at Section 9. Because
Yes.
Section 9, as I look at it, says that the physician has to say that this is a debilitating disease before the physician can make the prescription or...
Yeah.
Is that correct?
I'm sorry, go ahead.
I'm sorry, is that correct? That
Yes.
the physician has to say this is a debilitating disease?
That's right. That is a condition precedent to doing the certification. You have to say it's a debilitating disease. and then you have to say the benefits outweigh the risk.
Even
And
if
then you
it's
have to
one of
put
those
time limits.
diseases not listed? Even if it's something that's not listed, like the cancer
Yeah.
or glaucoma?
Yes, absolutely, and that's frankly one of the points, that the issue is there are other debilitating diseases in the future, and there are other debilitating diseases and conditions that a doctor may well determine, and to put this all on a list in the Constitution is not a good policy decision. And well, one of the things that sort of the proponents suggested that the sponsor doesn't dispute the fact that individual decisions alone determine when marijuana is appropriate. And we totally agree that that is exactly what we're saying, that individual physicians are in the position to make that decision. And Your Honor, I'd like to...
Is there such a thing as pharmaceutical marijuana now that physicians prescribe?
In some states, there's such things as Marinol and other types of things.
In Florida, I mean?
I think so.
Today?
But that's not, but it's not the same substance. It's a different substance. But yes, there are 20 states that have different versions of this. Okay, thank you, Your Honor.
Thank you.
Good morning again. Justice Quince, first I'd like to respond to your last question, where you said, does a doctor have to diagnose a person with a debilitating disease? And in fact, he does not. He has to diagnose the patient with a debilitating medical condition, which is a defined term in this provision. So the doctor does not have to find that the person has a debilitating disease?
So you're making a distinction between a debilitating disease and a debilitating medical condition?
There is a distinction, and the sponsors acknowledge that you don't even have to have a disease to get marijuana under this amendment. They've said in their brief that you can have marijuana if you have a disease. You can have marijuana if you have another condition that is not a disease. But the summary says exclusively you may have it if you have a debilitating disease as determined by a physician.
Well, it starts, the title though, one of the problems we have is that we've got a very unequal situation with constitutional amendments where the legislature has decided when it submits a ballot summary, it's limitless. They can put the whole amendment on, whereas citizens have this limit that the legislature has put on of 75 words. And I would hope that in the future, maybe the legislature would consider it might be easier to make sure that the citizens are on notice if the 75-word limit is just maybe too short. But here, do you agree that you read the title, this was certain medical conditions, in context with the text of the ballot summary? You don't just take one or isolate it from the other. So this will be known as a medical marijuana for certain medical conditions is how it would be known if it went on the ballot. And then is that correct?
Well, I agree that you would read them together, and this court has said you read them together. But when you read these together, you would believe that the debilitating diseases referenced in the summary are the conditions. And this court has never held that a broader title...
But I don't know,
Yes.
Explain that again. I would think, what I think in reading this is that it says debilitating diseases as prescribed, as determined by a doctor.
Right.
Okay.
But it doesn't have to be a disease, is the point.
But, okay, so you're saying the misleading part is that could be if I suffered from chronic back pain and I couldn't function because of the back pain. Is that a condition or a disease?
There is no dispute in front of this court that you do not have to have a disease
I know,
to have
but what
medical
is,
marijuana.
so where is the, what is it that an ordinary citizen would think would be included that's excluded or excluded that's included?
Well, an ordinary voter would read this summary and think that no one could have marijuana unless that person had a debilitating disease.
Except that,
And we
I
know
just
that's not
asked,
correct.
don't you read the title in conjunction, which says certain medical conditions?
You read them together, but the conditions that are referenced in the title, the voter would think are those debilitating diseases. And let me give you an example. In the SLU decision, this court looked at a title that said, this applies to school taxes. Applies to school taxes. And the court said that by implication, that meant only school taxes. That's what the title conveyed. And in the summary, the sponsor said it applied to non-homestead taxes, which the court acknowledged would include things other than school taxes. But the court said when you read those together, you would think that those non-homestead taxes are the school taxes. This court has never looked at a title and had it cure a misleading limitation in the summary. That's never happened. And obviously, in any situation, the title, which has to be 15 words or fewer by statute, is going to have a higher level of generality than the summary. If the argument they're making is correct, then it would not have been misleading to say allows medical marijuana for cancer and AIDS, period, if it said medical conditions in the title. Again, people would think that those things limited in the summary are what the title is referring to.
So you think the problem is, I mean, among other things, and I appreciate it, is the use of debilitating diseases. See, and again, I just didn't focus on that. I thought the main argument was that it sounded, if you read this, that this could only be prescribed for really horrible conditions.
Well, it's both.
And, I mean, it's both. So on that one, on the one as to whether this is open-ended and allows a doctor to prescribe marijuana for a headache or for anxiety before an exam, although I guess a student would be not a great thing to do before you took an exam. But what about the fact that you do have to look to decide whether it's misleading as to what the constitutional amendment itself means to cover? Do you agree that that's the starting point?
Sure. And
okay, so what about their argument that you've got to read subsection 1 together with 9, so that if the Department of Health started to see a doctor, for example, and you're there to enforce the Constitution, that was certifying, I gave this because the student has test anxiety, the Department of Health would say, listen, this is a doctor that we are going to seriously look at. They're not complying with the constitutional amendment. And at that point, then their argument, the idea is no, they've got to certify it's debilitating disease or condition. So why wouldn't do you think that's an impossible construction of this amendment? That is, that it is more narrow than the opponents are saying that it is?
Well, first, that doctor in your example would assert the immunity that this
only if they
provides.
follow. It's not immunity. It's liability, not immunity.
Immunity
only
from what?
if they follow the constitutional amendment. So if they are taking something and saying, "I think I can just do this for anything," it's up to the Department of Health to say, "No, these are the limitations on it," and then I guess there's a lawsuit. But
isn't that all keyed into what the physician believes?
That's right. That's what the
I mean,
limitation.
it's not what a reasonable physician would believe. It seems to be a subjective standard in here that would basically, as long as they're acting on some good faith basis, at the most, if they've got a good faith basis, they're off the hook for anything.
That's correct, and that's the only limitation. The only limitation is that a physician has to certify in his or her professional opinion the benefits of marijuana would exceed the risks.
But he must also include, as part of that certification, that the patient suffers from a debilitating medical condition, not just a condition.
Well, a debilitating...
That's part of the certification in 9. You would agree with that?
That's what it says, but, Your Honor, debilitating medical condition is a defined term. And we know that when you have a defined term, you rely exclusively on that term. And so to fit into the defined term of debilitating medical condition, you can have any condition for which a doctor...
Let me make sure then. I mean, it seems as though there's circular reasoning, so that what you're saying is that under this plan, that a physician would be certifying that the risks, that the benefits outweigh the risks, and then under the other provision, again, coming back that the benefits outweigh the risks.
Right, because the latter...
You're saying it certifies two of the same thing.
Well, look, there are...
That doesn't seem to be, I mean, a logical reading of much of anything if it's both saying the same thing.
Well, I think it would be dangerous indeed to read it differently based on what they created as a redundancy. This amendment has other redundancies, as well as filled with redundancies. To have an ID card as a personal caregiver, for example, you have to be a personal caregiver and you have to be 21 and you have to be willing to help. If you're a personal caregiver, by definition, you're 21 and willing to help. To be a qualifying patient, you have to have a physician certification and have a diagnosis of a medical condition, which you have to get a physician certification anyway. So there are certainly redundancies and other forms of illogic throughout this amendment, but that can't be a defense to what the plain language is. You don't ever get to any of these interpretive theories if the language is plain. And the language here is plain, that you have a debilitating medical condition. By definition, if you have a condition for which a physician has determined that the benefits of marijuana would exceed the risks. And we all know that there's a wide variety of opinions in the medical community about the risks of marijuana. And so if you're a physician who believes the risks are very low, there is no condition that would be beyond the scope. And it certainly doesn't have to be a disease. Now, another problem with the title is that it says certain, allows marijuana for certain medical conditions. The medical conditions at issue here, we know, are anything but certain. The sponsor has acknowledged that there are medical conditions that don't even exist yet today that may be eligible in the future because there's going to be a constant evolution in medicine.
Well, certainly you would agree that any dictionary would have multiple definitions of the word certain.
I would. In the first definition.
We've had it this week. Already we've been told that the word only doesn't mean only, so we've already been on that path this week.
But you have to ask why a sponsor, there are very few drafting exercises where the choice of words is more important than when you're drafting a title and summary for an initiative petition, precisely because of this court's review and precisely because of the constitutional right of the voters to understand have a fair understanding of what they're asked to vote on. And so you'd have to wonder why a sponsor would use the word certain, which has a primary dictionary definition of meaning fixed or settled when this is not, when they could have used another word like some or many, or they could have put at the end of it, allows for medical conditions whenever authorized by a physician.
Well, some or many wouldn't be in the same category because certain refers, to my mind, at least to some limitations on that. Some and any or many has no limitation at all.
Well, some would be, or they could say medical conditions as allowed by a physician. In fact, this very sponsor, and this is cited in the legislature's brief, they proposed an initiative petition to allow medical marijuana in 2009, collected tens of thousands of signatures, and then withdrew it. And that summary said it would allow marijuana for, and it lists things like HIV, glaucoma, some of the same things we see here. And at the end it says, or other diseases and conditions when recommended by a physician. They could have said that here, and then voters would have had notice that there is anything, it's up to the individual physician as to whether or not marijuana is going to be allowed.
And that in the summary would have cured what you believe to be the misrepresentation.
That would have addressed one of the misrepresentations.
Well, the one we're talking about.
There's a number of them. I mean, at its most fundamental level, what this amendment does is allows, at least under Florida law, some people to use marijuana in some circumstances for some conditions. And a voter reading this would not have any idea what that scope is. And this court has said a number of times that the proposal must present itself as neither more expansive nor less expansive than it actually is.
But if you say that the voter would not for sure know what the scope is, what we say in the right to drug treatment is that they have to also be on notice that you're going to need to look at the amendment. It's only if it's affirmatively misleading that we strike it. I realize we're here probably on a couple of different levels. There's debates about whether the use of medical marijuana or marijuana is a good thing or not. There are people that just want to legalize marijuana just generally. We obviously are not in that situation. And we're all clear, I think the Attorney General has been, that we're not here on the merits of what it is. But what it seems to me, reading this summary and ballot summary and title, that the voter is on notice that there will be limitations on the use of marijuana in this state, and that the physician is going to be key, because it says it's determined by the conditions. If the voter is more concerned about how broad it is, then they go to the amendment. Now, the amendment, you're saying it says one thing, the proponents say, no, it's not that broad. So unless, so isn't, I mean, again, it seems like the problem may be in the drafting of the amendment as opposed to in the title and summary. How do we deal with that?
Well, you deal with it by looking at what the summary says and asking whether a voter would be affirmatively misled. And they would. You're right that the voter...
Now, and what part would they be, that's what I'm trying to say, what part would they be affirmatively misled about?
The very first words of the proposal of the summary are, allows the medical use of marijuana for individuals with debilitating diseases as determined by a licensed physician. And the sponsor has acknowledged that you don't have to have any disease to have medical marijuana.
So it's back to this disease condition
Well, that's
thing.
one issue.
But what is, tell me the difference, and because again, I guess with condition and disease, I just wasn't focusing on that, with why that is a fatal flaw, that somebody thinks a disease, a debilitating, if I'm debilitated because of something medical, whether I call it a condition or a disease, that's what I'm concerned about. So what is it that's so important about the difference between one being a condition versus a disease that makes it affirmatively misleading?
Because of the scope of the use, how expansive it is. This many people may have diseases. This many people have medical conditions that are not diseases. If you talk, Chief Justice Polston's example of a person suffering anxiety, some of the examples we've talked about in our briefs, automobile accidents,
But I hear the
sports
proponents
injuries.
saying it's the intent of this amendment and reading the different sections together is not to allow it for these minimal situations.
Well, I'm not talking exclusively about minimal situations. We're talking about a football injury. That's not considered a disease, and you've not heard this sponsor, to my knowledge, tell you that a football injury would not be covered by this. Back pain, all of those things that are not diseases. The word disease doesn't even appear in the amendment itself, except in the context of the name of Parkinson's disease. They chose a word for the summary that's not in their amendment.
So if someone had debilitating back pain, that is, you're saying, was not a disease, therefore a voter would know, even though the title says certain medical conditions, that they would think, well, back pain isn't included, I mean, chronic debilitating back pain.
I think a voter would read the summary, which talks exclusively about debilitating diseases, and think that anyone without a debilitating disease will not be eligible for marijuana. Now, I'd like to talk about another issue separate from this disease issue that we haven't talked about yet, and that's the issue of federal law. A voter walking into the voting booth would walk out thinking that medical marijuana is lawful under federal law because of the choices that the sponsor made in putting the summary together. In fact, marijuana is illegal under federal law for medical use or otherwise, and every step of the process that this amendment would authorize, the growing, the transportation, the selling, the buying, the smoking of marijuana would be a federal criminal offense.
But then the last sentence of the summary, specifically states, does not authorize violations of federal law or any non-medical use, possession or production of marijuana.
That's right. And what that tells voters, Justice Lewis, is that the medical use of marijuana is not a violation of federal law. If you said, for example, if the summary...
This says it does not authorize violations of federal law.
It says that, Justice Lewis, right after it says what it does authorize, which is the medical use of marijuana. It says we authorize the medical use of marijuana. We do not authorize the violation of federal law. So voters would think necessarily those things are distinct. Imagine if a summary said, we will allow marijuana, but we will not allow any Schedule I substances. What does that communicate to the voter other than that marijuana is not a Schedule I substance? And it is. And I think if you look at the actual amendment itself, it doesn't say does not authorize violations of federal law. It says does not require violations of federal law. And that's very different, and that has some significance to the extent there's ever a preemption analysis. But they selected to put in the summary does not allow violations of federal law right after telling the voters what it does allow, which is medical marijuana. And so what that communicates to voters is that medical marijuana, as opposed to maybe recreational marijuana or other drug use, is not a violation of federal law. And we know that it is. I'd also like to
But let me say, so
Yes.
they would it be better if they didn't say anything? I mean, what's happening in all these states that either most of them are doing it through the legislative process that you pointed out, is that medical marijuana is a violation of federal law. Is it not? Is the state use, authorizing use of medical marijuana still violates federal law?
Any medical use of marijuana violates, there's a very small exception for medical trials.
But the federal government has said they're not prosecuting. So
That's
they,
not-
So they, what?
Well, the
So
federal
would you
government...
want them to say, it can't authorize violations of federal law?
Right.
So,
So you wonder why that's in there?
well, it seems that it's saying, listen, this still could be a violation of federal law. It says this applies only to Florida law. You may still, even if you do this, doctor, you still may be violating federal law. I mean, I think that if it wasn't in there, you might say, listen, it doesn't tell them that this could be a violation of federal law. I mean, that's we had that with term limits. I
Sure.
mean, this may be, unconstitutional under, or, illegal under federal law. So I'm not sure why that's misleading.
It's misleading because of the way they worded it. They worded it to suggest. It's not about voters who are not getting noticed that it's violating federal law. It's that voters are getting noticed that it does not violate federal law, which is in fact incorrect. You say it allows A, it does not allow B. People are going to think A and B are different things. A and B in this case are exactly the same thing. The medical use of marijuana is a violation of federal law. Everything that this purports to authorize is a violation of federal law. They tell voters it allows medical marijuana. Of course, it allows it for purposes of Florida statutes or Florida law, but it does not allow it because it remains a violation of federal law. And if you also look at how they chose to present it with the other things that this does not do, and to your point, Justice Lewis, about the last sentence, does not authorize violations of federal law or non-medical use, possession, or production of marijuana. You can have a law that authorizes medical use of marijuana without allowing non-medical use of marijuana. So they group that with things that are distinct from the medical use of marijuana. But the violations of federal law are not distinct from the use of medical marijuana. It's the same thing. And so there was really no need to put does not allow non-medical use in there other than to group it with the authorization of federal law. And so this is, I think, a very good example of the wordsmithing that this court has said is inappropriate. And certainly there's going to be a different response from the voter if instead of saying we're authorizing marijuana, we're not authorizing violations of federal law, if it would have just simply said federal law will continue to prohibit or something like that. Something to let voters know that whatever they want to achieve under this will remain a federal criminal violation. And Justice Perriente, to your point about the federal government announcing they're not, that is a memo that deals with enforcement priorities. It is not a statement by the federal government that they won't prosecute. And they explicitly carved out minors from that remains a priority.
Yeah, so if I were a physician, I wouldn't, and my lawyer told me that if I do this, I might be okay under Florida law, but I'm not going to be going to federal law. I think that'd have a pretty chilling effect on the scope of this amendment anyway.
It may have a chilling effect, but the voters are entitled to the truth, and if the truth has a chilling effect, then so be it. And what this court has said time and again...
I didn't really pick that. Again, I know you've spent a lot of time reading and rereading, and I appreciate your arguments are done very professionally, and I appreciate position. I just didn't pick up on that part was at all problematic because it seemed to acknowledge that federal law might still prohibit it. I mean, that's...
Well, I think it does not acknowledge that. I mean, that's the argument, and I think that the words
You think
put in
they
there...
affirmatively try to, this is like one of these sleight of hand wordsmithing sentences that they put at the end?
Well, I don't presume to know their intentions, but the choice of words results in a summary that suggests something that is plainly untrue, and that is that federal law does not prohibit it. They did deviate from the language in the amendment. The amendment says does not purport to authorize violations of federal law. That would raise the eyebrows of a voter if someone said...
This is why this is so problematic with they're at 75 words, and, every additional word ends up causing a problem.
Well, first, this court has said a number of times that the 75-word limit is not an excuse to evade the responsibility to inform the voters. Second, a lot of the problems...
Inform the voters of the chief purpose, and that's what, but the issue of whether it's what they put in is affirmatively misleading is the more... the more problematic
The
issue.
problems in this summary, Justice Parenti, are not caused by the 75-word limit. A lot of the problems in this amendment are words they chose to add that they shouldn't have added, like debilitating diseases. And certainly these things at the end that I indicated about federal law, about the non-medical use. Why would you need to use words telling people that an amendment whose chief purpose is to allow medical use does not also allow non-medical use? And they have details in there about the ID provisions, which are certainly the ID cards, which are certainly not a prominent feature of this amendment. What is a prominent feature of this amendment are the immunities, the civil, criminal, and disciplinary immunities given to physicians. That is a priority. That is number 2 on their list of public policy issues in the amendment itself. But the voter has no notice of the immunity at all, none at all.
Could a physician certify something saying that there was a greater potential use than the health risk, but in fact malpractice and the opposite is true, and somehow harming the patient? And in that instance, wouldn't the physician be not liable under medical malpractice?
The hypothetical is that a physician issues a physician certification negligently.
Just gets it wrong, malpractices.
They would absolutely turn to this liability provision here.
So they're immune from suit under this provision.
Yes, Your Honor. I mean, you look at the plain language of the amendment. It says a physician shall not be subject to criminal or civil liability or sanctions under Florida law for issuing a physician certification to a person diagnosed with a debilitating medical condition, which we know is a defined term, in a manner consistent with this section. And the section has nothing about standard of care. All the section says is that you have to do a physical examination to whatever extent that you find appropriate, I suppose, and you have to examine the medical history. That's all it says. And certainly the sponsor's goal here is to promote the use of marijuana and to allow medical marijuana, that is, and to allow physicians the freedom to certify this. And you've heard the counsel say that it does come down to the individual physician in every instance about what he or she believes. And so that fits in with this by giving them immunity in that sense. It doesn't fit in a single subject sense, and that's something that I'd like to spend the remaining time on if the court has no further questions on the ballot summary. But here you have a combination of different subjects that are discrete, that violate the single subject rule. The single subject rule is a rule of restraint, and the purpose was to stop things that don't necessarily go together from being put in to an amendment together, and it's unique to the citizen initiative. It's to protect against precipitous change. So here you have a policy of legalizing medical marijuana, and then you have a completely separate topic of putting the regulatory functions all into a statutory agency, giving that executive agency substantial regulatory authority that they don't have without the same kinds of oversights that you'd have through the APA from the legislature. And it also combines the immunity. You could certainly imagine a amendment that allowed medical use of marijuana without providing physicians the immunity that this provides. And they say it doesn't provide as broadly as we say it does, but it does something. We can't ignore the words that are there. And the sponsor said in its initial brief that physicians are already recommending marijuana and that the purpose of their amendment is to allow patients to follow up on those recommendations without fear of criminal prosecution. And that's fine. But whatever physicians are doing now, they're subject to a standard of care, and the liability that they have now, civil liability that they have now, would go away under this amendment. And that is a log-rolling violation. It's also a violation because it doesn't identify the other constitutional rights at issue, namely the access to courts constitutional right in our Declaration of Rights, as well as a separate amendment that deals with the discipline of physicians. So you have very separate features all rolled into one, and that violates the single subject rule. I'd like to respond to the arguments that the sponsor makes in the brief that this is really about a policy debate and that people should have the right to vote on this issue.
But that's not really what controls our decision-making process, whether it's a good idea, bad idea, whether you like it, somebody else doesn't. I mean, all we're looking at is the words and what it tells the people of Florida, isn't it?
That's right. That's right. And so, and what the court said in the Slough decision is that the sponsors have an obligation to get it right. They have to be very careful, and they have to provide the fair notice. And that if they use that situation to try and market their proposal, if they use that to try and convince voters to vote for their proposal as opposed to providing fair information, they run the very risk that the sponsors ran here, which is that the court would remove it from the ballot to protect the voters from being asked to support something they didn't have. So it was up to the sponsors to make a complete, fair ballot summary. It was up to the sponsors to draft an amendment that did not violate the single subject rule. And this court should remove this from the ballot. And if the court has no further questions, I'll have a seat.
Thank you. Rebuttal.
Thank you.
May it please the court, in response to several questions, there's an overall issue about the title and summary. This court's precedents in title and summary are exactly what Justice Perriente discussed. Does it put somebody on fair notice? Does not have to be perfect.
Well, you can,
Does not have to be.
what about this use of disease versus that it's debilitating conditions? It seems it would have been, why was disease put in when it's not in the amendment?
But one of the things that this court has done consistently is look at words used in title and summary and words used in text. All of the words, that is, condition, disease, and physician decision, are in the title and summary and in the text. And the title says condition.
The word disease does not appear in the same context as it is in the summary. I mean, it appears in Parkinson's disease. Is that correct?
And there are several other conditions that are diseases. I believe cancer is a disease. There are other diseases. And in fact, there are a number of diseases which could be and will be debilitating medical conditions. And Your Honor, Justice Kennedy, I want to respond to the subjective decision of a physician. That's absolutely not the case. That there's nothing in this amendment that repeals the standards of care.
But it says for which a physician believes that the medical use, and that's in the definition of debilitating medical condition, okay? The physician's belief is the focus there. And then you have the broad language of immunity. I don't understand how that doesn't throw the ordinary standard of care out the window.
In certification, that physician must sign in their professional opinion. That's what Section 9 says. And if they exercise their professional opinion negligently, they are negligent. And this court and no court...
How can that possibly stand in the light of the language in subsection 2 when it says they shall not be liable?
They shall not be liable for the single act of issuance. I mean, that's the act of issuance, not issuing it negligently.
But the whole purpose of what you're talking about, the reason that the definition survives is the care taken by the physician and the review by the physician, which is now not subject to liability under their review.
The physician is, Your Honor, I would suggest that the physician, the courts have never, by implication, repealed standards for care, standards for professional conduct. And this is, the language simply says, for the act. And if it didn't do that, then physicians would not be able to prescribe, to certify. And if I may, on the certain elected, on the certain condition, the certain condition is a perfect example of context. That in this context, if you read it, it obviously means certain conditions that involve decisions by a physician. They cited a case, which was also correct, certain elected offices, which was a list. So in each case, you had to look at context.
But again, I'm confused by this argument because the context that the voter is looking at is a context in which the voter will see the reference to certain medical conditions followed immediately by the ballot summary that refers to debilitating diseases. Now, I don't know why a voter looking at that isn't going to understand, oh, it's referring to medical conditions that are debilitating diseases.
Well, Your Honor, I think if you read the two of them together, and a voter will understand that there are debilitating medical conditions and there are debilitating diseases. I understand your position, but
let me ask you because your time is about out here. I want to ask you about the provision on federal law. What does it mean in the ballot summary when it says does not authorize violations of federal law? What does that mean?
Well, it's putting the voter on notice that nothing in this amendment does that, and there is...
But it does.
Well,
it certainly authorizes conduct under state law, which would be conduct that violates federal law. Isn't that the case?
and the voter could be expected to understand that, and very specifically...
But it says it doesn't. It doesn't authorize violations of federal law when it is authorizing conduct that constitutes violations of federal law. It seems to me that it would be easy, that this is just a confusing statement that is likely to lead people to believe that nothing in here that is authorized here is going to be illegal under federal law. Now, it's obvious that the state of Florida cannot change federal law. Wouldn't you think that that's obvious?
Well, I see my time's expired. If I may respond to that.
Mr. Chief Justice, could he have an opportunity to answer that?
Please.
The important part about conveying that to the voter is, I'll cite again to the limited casinos case, where this court said the voter is expected to know, and in that case, knows that casinos are not authorized. So I think that we can expect a voter to understand something about the context of this. And in conclusion, Your Honor, this proposal is a narrow policy proposal. The explanation within the 75-word limit conveys to the average voter the chief purpose in a way that is readily understandable. Thank you, Your Honor.
Thank you for your arguments. The court will be in recess for 10 minutes.
All rise.